Good afternoon, everyone. This meeting is called to order. Mr. Trillman, has anyone signed up for public comment?
Good afternoon, Commissioners. Les Trubman, General Counsel. We have one person who would like to address the commission this afternoon. Ms. Rosby, if you can go ahead and unmute yourself and introduce yourself and begin. Ms. Rosby?
Can you hear me?
Yes, we can. Go ahead.
Okay. During this, I will, start with my public comment. During the stressful time of pandemic and not having a job, I made an honest mistake on the payment request for the period November 22nd to December 26th, 2020. By reporting that I was not available to work due to my age more than 65 and underlying health condition, diabetes. I was unaware that Governor of Texas and the Director of TWC have withdrawn their earlier decision to accept older people with underlying health condition from job search. I corrected that mistake from the payment request starting from December 27th, 2020 onward. I received 2 vaccines during March 2021. During the 2-week payment request period of April 4 to 10th and April 11 to 17th, 2021, I got a job and started working during the week of April 11th. I only requested payment for 1 week, April 4 to 10th. For the week of 11 to 17, I even reported my estimated income for that 1 week. On November 19th, 2021, I received the booster shot. I was at my full-time work when I received the booster, and I'm still working at the same place now. On the decision from Commission Appeals, it reads, as the claimant was released to return to full-time work by her doctor on November 19th, 2021. This is a wrong statement. I cannot understand how TWC got mixed up with my date of receiving booster as my date of going back to full-time work. I started full-time work in April 2021. TWC stopped paying my unemployment benefit after February 20th, 2021. I submitted payment requests for 7 more weeks after February 20th, 2021 till I got the job in April. TWC did not pay me anything for these 7 weeks. TWC paid me for November 22nd to December 26, 2020, and from December 27, 2020 to February 20th, 2021. I made an honest mistake for the first period. I did everything correctly for the second period. Now TWC wants me to repay for these 2 periods. And I think it's not fair with me. And this is, I want to put this on my public comment on record. Thank you so much.
Thank you. Commissioners, that's all we have. Public comment today.
Yes.
Thank you.
Thank you.
Thank you. Good afternoon, Ms. Miller.
Good afternoon, sir.
How are we today?
Very well, thank you.
All right, let's dig in. We have no cases to reconsider under agenda item 3.
Correct, no cases.
Let's look at tax liability cases under agenda item 4. I believe we have tax cases to consider on all 3 dockets.
That's correct. There's one case on docket 5. It's case number TD-22-030-0922. Commissioner Demerson,
I agree with staff recommendation.
Commissioner Trevino,
I agree with staff recommendations.
and Mr. Chairman.
Agree with staff recommendation.
On docket 6, there's also one case. It's case number TD-22-041-1122. Commissioner Demerson,
I agree with staff recommendation.
Commissioner Trevino,
I agree with staff recommendations.
and Mr. Chairman.
Agree with staff recommendation.
Thank you. And on docket 7, there are 2 cases. The first case is case number TD-22-017-0622. Commissioner Demerson,
I agree with staff recommendation.
Commissioner Trevino,
I agree with staff's recommendation.
and Mr. Chairman.
Agree with staff recommendation.
And the last case is TD 22 020 0722. Commissioner Dimerson,
I agree with staff recommendation.
Commissioner Trevino,
I agree with staff's recommendation.
and Mr. Chairman.
Agree with staff recommendation.
Thank you. That concludes the tax cases.
No fair housing cases under agenda item 5.
Correct? No cases.
Under agenda item 6, we have one wage claim case on docket 5 and no cases on dockets 6 or 7.
That is correct. The one case pulled on docket 5 is case number 21-055-859-4. I believe this was pulled by your office, Commissioner Trevino.
That is correct. Section 362 of the U.S. Bankruptcy Code requires a stay of continuation of judicial, administrative, and other action or proceedings against a debtor who has filed bankruptcy petition. It seems the issuance of the decision, especially one that provides the parties with appeal rights, may violate these automatic stay provisions. This case should be held pending a memo from the Office of General Counsel regarding whether it is appropriate to issue a decision on a case where there has been an automatic stay under Section 362 of the U.S. Bankruptcy Code. Additionally, I would request that the memo address how the agency has typically handled cases before the commission when a bankruptcy petition has been filed.
Although the AT decision held that the employer's appeal from the wage claim judgment must be dismissed due to lateness, since the employer has filed a bankruptcy action in federal court under the Bankruptcy Act, that federal law requires TWC to stay any further action on the wage claim until the bankruptcy action has been resolved. Accordingly, we should issue a decision staying any further action on the claimant's wage claim until the federal proceeding has concluded.
Stay pending bankruptcy proceedings.
All right, we'll go ahead and issue the stay decision, sir. Did you want to dissent? You may still request an OGC memo if you like, but it won't hold up the decision in this case.
Yes, I'll short form dissent, but I would still request the memo.
Right, we'll send that. Thank you.
Thank you, ma'am.
So those were all the cases pulled for the wage claim cases pulled for additional discussion. On dockets 5, 6, and 7, you should have received the wage claim short form dissent list for dockets 5, 6, and 7.
I move we accept staff recommendations on remaining wage claim cases on dockets 5, 6, and 7.
And I second the chairman's motion, except for the cases on which I'm dissenting as reflected in the wage claim short form dissent list for dockets 5, 6, and 7.
And I concur with Chairman's motion, except for those cases on which I am dissenting as reflected on wage claim short form dissent list for docket 5, 6, and 7.
Motion passes with the exceptions noted.
Thank you.
Thank you. We'll now move to agenda item 7 in consideration of unemployment insurance cases. Please proceed when you're ready.
We'll begin with docket 5.
Case number 291-5624, Commissioner Dimerson.
We should remand this case back to the appeal tribunal. The record was not sufficiently developed concerning the issue of good cause. The AT concluded that the employer did not have good cause for its non-appearance, yet failed to ask the basic foundational questions needed to establish whether the employer even received the hearing notice in question. Because the employer alleges non-receipt of a hearing notice in its appeal to the commission, and the record was not adequately developed on the good cause issues, we should remand this case to the appeal tribunal.
We should affirm the AT decision. The employer missed 2 hearings because they believed they did not need to attend either hearing as they had already provided information about the claim. The employer was not prevented from participating due to circumstances beyond their control and did not establish good cause to reopen the hearings. Affirm the AT. Employer did not have good cause for missing the hearings. Charge back.
I concur with Commissioner Dimerson.
We will remand the case. And this case will issue a decision. Would you like to short form dissent?
Short form dissent.
Yes, sir. Thank you.
Thank you.
Case number 293-5802, Commissioner Trevino.
The timely motion for rehearing should be granted to admit additional documentation provided by the claimant not previously included in the record. Grant the motion for rehearing.
While I sympathize with the claimant's personal circumstances, the claimant motion for rehearing offers no new evidence that was previously unavailable for a compelling reason, and that would change the outcome of the case. Under TWC criteria for a motion for rehearing, the claimant's motion cannot be granted. Accordingly, we should deny the claimant's motion for rehearing, leaving the prior determinations in place.
Deny the motion for rehearing.
Short form dissent.
Yes, sir.
Case number 3023785, Commissioner Trevino.
The AT decision should be modified. The claimant testified that he had school-age children that had to stay home due to COVID-19 school closures. The claimant further testified that he was a primary caregiver and had to stay home with his children during the closures. Therefore, the claimant met a qualifying reason for a PUA eligibility and should have been qualified for PUA benefits for any period in which he filed for PUA benefits while his children were unable to attend school due to COVID closures. Modify the AT eligible for PUA benefits beginning October 11th, 2020, and the first date of the claimant file for PUA.
So the date range would be November 10th, 2019 through October 10th, 2020.
It's going to be October 11th, 2020,
As the closure date.
the first date that they filed first date he filed the PUA, correct?
Okay, I'm sorry. I think I missed something. There's an opening date and a closing date. What's the opening date, sir? The determination opened at November 10th, 2019.
All right, I have a opening date of November 7th of 2019, but we're just stating that it'll be eligible October 11th of 2020 when the first date that the claimant filed the PUA.
Okay, so eligible beginning October 11th, 2020.
That is correct, ma'am.
All right, I'm going to document that as a closure date because it falls after the opening date.
Okay, that's fine.
Thank you.
The AT decision may be supportable, but since the claimant does not speak English, it would be best for a due process standpoint to allow one more chance for him to testify about the facts relevant to his PUA eligibility. Prior to the rehearing, an appropriate staff member from the UI division should, with the assistance of an interpreter, contact the claimant to ensure that he understands the importance of relevant information pertaining to the PUA program and has had a chance to gather the information prior to the rehearing. When the case is resubmitted after the rehearing, there should also be an analysis of the potential relevance of subsection K on page I-6 of the U.S. Department of Labor's official guidance on the PUA program. For example, the UI program letter 16 through 20.
So your vote is to rehear following UI contact with the claimant.
That's correct.
Thank you.
I concur with Commissioner Demerson.
Thank you. We will instruct UI of your instructions and rehear once that's done.
Thank you.
And there isn't a decision being issued for this one yet.
Okay, thank you, ma'am.
Case number 3193063, Commissioner Trevino.
The AT decision is not supportable. The hearing was scheduled over a year after the appeal was filed. As a delay in scheduling, the hearing contributed to the claimant's non-appearance. The claimant established good cause for missing the hearing. Although the claimant's appeal was late, as the determination created an ongoing ineligibility, the commission should assume continuing jurisdiction as of April 23 of 2021. The claimant lost his job when the employer closed due to the pandemic. There is no evidence as to when or if the employer reopened or whether the claimant was offered an opportunity to return to work. Therefore, the claimant is eligible for PUA benefits. Reverse the AT, claimant established good cause, claimant appeal not timely, PUA not eligible from December 6, 2020 through April 24th, 2021.
The AT decision is not supportable on the issue of whether the claimant had good cause to miss the first appeal hearing. Due to the passage of time between the claimant's original appeal and the first appeal hearing, he had good cause to miss the hearing. Concerning the late appeal issue, the claimant's original appeal was 3 months late. Did not offer any evidence showing that an exception under Commission Rule 32 would apply. I agree that the claimant's ineligibility for PUA benefits should be left in effect since his testimony concerning his circumstances after the jurisdictional date of April 23rd, 2021 did not indicate that he met any of the PUA program requirements for the period after that date. Accordingly, we should reverse the AT decision. The claimant had good cause to miss the first hearing. The claimant filed a late appeal. The PUA ineligibility determination is left in effect.
Reverse AT, claimant established good cause for AT1, untimely claimant appeal, PUA not eligible beginning December 6, 2020.
And remaining open.
Yes.
Thank you. So the ineligibility remains open.
Okay, ma'am. Short form consent.
Yes, sir.
Thank you.
Case number 3193093. Commissioner, excuse me, Commissioner Trevino.
Yes, sir. The timely motion for rehearing should be granted to admit additional documentation provided by the claimant not previously included in the record. Grant motion for rehearing.
Just as with the companion case on this docket, the claimant's motion for rehearing offers no new evidence that was previously unavailable for compelling reason, and that would change the outcome of the case. And so again, while I sympathize with the circumstances concerning this case, TWC criteria for a motion for rehearing the claimant's motion cannot be granted. Accordingly, we should deny the claimant's motion for rehearing, leaving the prior determinations in place.
Deny the motion for rehearing.
Thank you.
Short form dissent.
Yes, sir.
Case number 3236352, Commissioner Dimerson.
The AT decision is not supportable. The initial claim notice and the determination that the employer had filed a late protest were both sent to an address that did not match the employer's address of record in the employer master file. Specifically, the company name was misidentified. Under Commission President, TWC misaddressing a claim notice, our determination is an exception to the timeliness rules in Commission Rule 32. Combined with the facts that the work separation occurred in late 2020 and that the employer was under the reasonable impression that its account would be protected from chargeback due to the pandemic-related reasons for the layoff, the employer's claim response and subsequent appeal should both be considered timely. Accordingly, we should reverse the AT decision. The employer filed a timely appeal and a timely protest, resubmit on the merits of the work separation and the chargeback issues.
The AT decision should be affirmed. The employer confirmed receiving the determination in the mail and reading the deadline to appeal. The employer also confirmed that they did not file a timely appeal to the determination. The employer does not offer any explanation that provides an exception to the timeliness rules. Therefore, it is proper to dismiss the employer's appeal as late. Affirm the AT decision, late employer appeal, the determination is left in full force and effect.
Reverse the AT, timely employer appeal, resubmit.
We have majority vote on the timeliness of appeal issue, but no majority vote yet on the timeliness of protest issue. As the chairman said, resubmit, and you provided an actual result in the issue.
So we're filed a timely appeal and a timely protest, and then resubmit. And what was the chairman?
Timely appeal and resubmit with no specific vote on the timeliness
On the
of protest.
All right, let me consult real quick.
Mhm.
I agree with the chairman.
Thank you. We'll
Thank you.
resubmit the case on timeliness of protest, and then we'll see the results on the underlying merits.
Sounds good. Thank you.
Thank you. And this will be resubmitted, sir.
Okay, ma'am. Thank you.
Case number 327-3481, Commissioner Dimerson.
We should reverse the appeal tribunal decision. The available record shows that the claimant was observed in an inebriated fashion operating heavy equipment by various witnesses at the employer's workplace. Although the employer made a reasonable request for the claimant to be tested for alcohol, the claimant refused to abide by the employer's instructions and was hence discharged from employment. Since the employer made a reasonable request for the claimant to be tested for alcohol based on the claimant's intoxicated state, his failure to abide by the employer's instructions was mismanagement of his position of employment and was misconduct connected with the work. Hence, we should reverse the AT decision, misconduct, no chargeback, adequate employer response. In the alternative, the commission should conduct a rehearing in this case. The hearing officer failed to properly develop the record about the employer's policy or question the parties regarding the claimant's acknowledgement and subsequent refusal of the employer's request to take an alcohol test. As such, the commission should conduct a rehearing to develop the record about the circumstances which led to the claimant's separation.
The AT decision should be affirmed. The claimant was charged for refusing to take an alcohol test, even though the employer had no policy requiring employees to submit to drug or alcohol testing. The claimant had no notice that he would be discharged for refusing to take a test and was not warned that he could be discharged for refusing to take the test. The claimant denied that he was intoxicated, and the employer's allegations regarding the claimant's alleged intoxication were based on unsworn written statements and hearsay testimony. The employer submitted insufficient evidence to establish misconduct. Affirm the AT, no misconduct, and chargeback.
Affirm the AT, no misconduct, chargeback.
Short form dissent.
Yes, sir.
Case number 3294003, Commissioner Trevino.
The AT decision is not supportable. The claimant provided the only firsthand testimony and testified that he did not refuse any work assignments on the day of the final incident. Therefore, the employer has failed to establish that the claimant was discharged for misconduct connected with the work. Reverse the AT, no misconduct.
The appeal tribunal decision should be affirmed. Per the employer, the claimant was discharged for refusing to do work that was assigned to him. In addition, the employer stated that the claimant had been warned that refusal of a work assignment given by the employer violated corporate policy. As such, the claimant mismanaged his position of employment, and we should affirm the AT decision misconduct.
Reverse the AT, no misconduct.
Short form dissent.
Yes, sir.
Thank you.
Case number 3332800, Commissioner Dimerson.
We should modify the appeal tribunal decision. The claimant in his fact-finding statements alleged that he was unable to meet the employer's expectations due to a hearing impairment. Since the available evidence shows that the claimant's separation arose from his medically verifiable illness, we should modify the AT decision. No misconduct, no chargeback, MVI.
The AT decision should be affirmed. The claimant made the employer aware that one of his assistive medical devices stopped working and tried to get a replacement device. The claimant's inability to meet the employer's quality of standard after his assistive medical device failed is not misconduct. Affirm the AT, no misconduct, chargeback. In the alternative, I could agree that the claimant's discharge was by the claimant's medically verifiable illness. So I'd modify the AT decision, no misconduct, no chargeback, MVI.
Modify the AT, no misconduct, no chargeback, MVI.
Do you want me to count yours as an MVI vote or a dissent?
Could you repeat that, ma'am?
You gave me two options. The majority vote is MVI. One of your votes was MVI, but the other one was not. Which one do you want me to count as your final vote?
I'll agree with the MVI.
Thank you. It's a unanimous decision. And that was the last UI case pulled for additional discussion for docket 5. You should have received the UI short form dissent list for docket 5.
I move we accept staff recommendations on the remaining UI cases on docket 5, except for the cases which I am dissenting as reflected on the UI short form dissent list for docket 5.
And I second the chairman's motion, except for the cases on which I'm dissenting is reflected in the UI short form dissent list for docket 5.
And I concur with the chairman's motion, except for those cases on which I am dissenting, as reflected on UI short form dissent list for docket 5.
Motion passes with the exceptions noted.
And going on to docket 6.
Case number 2714477, Commissioner Trevino.
The AT decision should be modified. The claimant quit to care for her disabled minor child. Her older child, who was providing care services for the disabled 4-year-old child, became suicidal and had to leave the claimant's house. Since the claimant had to quit due to her children's medical conditions, the claimant had good cause connected with the work for quitting. Modify the AT, no voluntary leaving, no chargeback, MVI.
We should affirm the appeal tribunal decision. Although we sympathize with the claimant, the available record shows that the claimant's separation was clearly personal and unrelated to the work. As such, the claimant failed to establish a good work-related reason for quitting. Hence, we should affirm the AT decision, voluntary leaving, no chargeback.
Modify the AT, no voluntary leaving, no chargeback, urgent and compelling, memo to investigate availability.
All right, we have majority vote that the claimant will be paid and the employer protected, but the rationales are different.
Okay, I'll agree with the chairman.
Very well, urgent and compelling.
Short form dissent.
Yes, sir.
Case number 2720707, Commissioner Trevino.
The AT decision is not supportable. The claimant received a notice of a hearing and attempted to participate by registering for the hearing online. She was unable to register due to issues with her internet connection. The claimant made a good faith effort to participate in the hearing, but was prevented from doing so by circumstances beyond her control. Therefore, the claimant has established good cause for her failure to participate in the AT1. Reverse the AT, claimant established good cause for AT1 and resubmit.
We should affirm the appeal tribunal decision concerning good cause. Although the claimant was aware of the time and date for the AT hearing, she did not attend the hearing because she was overwhelmed with the process for registering. Since the claimant did not establish by credible and persuasive evidence that she was prevented from appearing at the AT1 hearing due to circumstances beyond her control, the claimant did not establish good cause. Concerning the issue of severance, the claimant received severance pay for a period of 1 year. Since the record suggests that the severance pay was not conditioned on any of the non-disqualifying factors found in 207.049B of the Act, we should affirm the AT decision. The claimant did not have good cause for a non-appearance. Severance disqualifications from September 27th, 2020 through September 25th, 2021.
Reverse the AT, claimant established good cause for AT1, resubmit.
We will resubmit the case.
Case number 2938846, Commissioner Trevino.
The AT decision is not supportable. The separation determination at issue in this case, which qualified the claimant to receive benefits, was mailed on September 4th, 2020. The claimant received benefits until she stopped filing payments requests for the benefit week ending January 23rd, 2021. Therefore, the claimant was not aware that she needed to update her address with the commission when she left her record or her address of record. Since the claimant did not receive the AT1 decision due to a delay in the scheduling of the hearing in her case, the claimant's petition to reopen should be deemed timely. Reverse the AT, claimant filed a timely petition to reopen and resubmit.
We should affirm the appeal tribunal decision. The claimant was responsible for updating the commission with her correct address of record. Although the AT decision was sent to the claimant's address of record provided to the commission, she did not file an appeal within the applicable deadline. Since the claimant's petition to reopen was not timely, we don't have jurisdiction to consider the underlying merits. As such, we should affirm the AT decision. The claimant filed a late petition to reopen, misconduct, no chargeback, adequate employer response.
Reverse the AT, timely petition to reopen, resubmit.
We will resubmit the case.
Case number 3008469, Chairman Daniel.
Because the employer's appeal timeframe occurred when TWC systems were overwhelmed and because the commission communicated to the public on multiple occasions that no employer would be charged based on claims caused by the pandemic, the employer could have reasonably relied upon that information and been misled into failing to respond timely. The response should be deemed timely and the case resubmitted. Reverse the AT, timely response to the NMPC, resubmit.
I would agree with the chairman.
Okay, the notice of maximum potential chargeback was sent to the employer electronically. The testimony only addressed notices the employer received through the mail. It would be appropriate to remand this case to address the employer's receipt of the notice electronically. Remand.
Thank you. The majority vote is that there was a timely response and to resubmit. This will be resubmitted, so there's no dissent necessary.
And thank you.
Case number 3040688, Commissioner Trevino.
The decision is not supportable. The separation determination at issue in this case, which qualified the claimant to receive benefits, was mailed on February 10th, 2021. The claimant had stopped filing payment requests after the benefit week ending May 1st, 2021. Therefore, the claimant was not aware that she needed to update her address with the commission when she left her address of record in September 2021. Since the claimant did not receive the AT1 decision due to a delay in scheduling a hearing case, the claimant's petition to reopen should be deemed timely and the case resubmitted for merits. Reverse the AT, claimant filed a timely petition to reopen and resubmit.
The appeal tribunal decision should be affirmed. The claimant filed her petition to reopen beyond the applicable deadline to do so. In addition, the claimant did not provide sufficient evidence to overcome the presumption of receipt. There are no good cause exceptions to the timeliness rules. Accordingly, we should affirm the AT decision. Untimely petition to reopen, leave the underlying decision in full force and effect.
Reverse the AT, timely petition to reopen, resubmit.
We will resubmit the case.
Case number 3175101, Commissioner Trevino.
The claimant's appeal, which was mailed one day after the appeal deadline, included copies of multiple fax attempts to the commission from the day before. The fax confirmation reports indicated the fax did not go through because of a technical problem on the commission's end. Therefore, we should deem the claimant's appeal to the commission timely and the case should be resubmitted for merits. Deemed timely and resubmit. And in the alternative, I could agree to rehear the case on the timeliness issue.
We should dismiss the claimant's appeal to the commission. The claimant's appeal was one day late. Although she submitted proof of fax attempts, she did not submit proof of a timely filing as required by President. Accordingly, since there are no good cause exceptions to the timeliness rules and the claimant does not meet any of the timeliness exceptions, we do not have jurisdiction to consider the underlying merits. We should dismiss the claimant's appeal to the commission as late and leave the underlying AT decision in full force and effect.
Late commission appeal, the AT decision remains in full force and effect, but I would like a briefing on all known issues affecting CA's fax machines on May 18th, 2022.
Okay, short form dissent. ma'am.
Yes, sir.
Thank you.
Case number 3229538, Commissioner Dimerson.
The appeal tribunal decision should be reversed. The majority of the employer's appeal period took place during the time that TWC was experiencing technical difficulties during the pandemic period. As such, the employer's response to the notice of maximum potential chargeback should be deemed timely. Accordingly, we should reverse the AT decision. Timely response to the notice of maximum potential chargeback, resubmit.
The AT decision should be affirmed. The employer filed a late response to the notice of maximum potential chargeback. While the employer alleged non-receipt of the notice due to an incorrect mailing address, this testimony lacks credibility as the employer utilized this mailing address for 5 years. The employer was at fault for the non-receipt of the notice since they provided the mailing address to the commission. The notice was properly mailed to the employer, and there is no good cause exception to the timeliness rules. Affirm the AT late response to the notice of maximum potential chargeback and charge the employer's account.
Reverse the AT, timely response to the NMPC, resubmit.
And I believe you said resubmit as well.
Resubmit.
Thank you. We'll resubmit the
Thank you.
case.
Thank you.
Case number 3233740, Commissioner Trevino.
The AT decision is not supportable. The claimant missed the hearing due to a recent change in his medication affecting his memory. Therefore, the claimant established good cause for non-appearance and the case should be resubmitted. Reverse the AT, good cause, and resubmit. In the alternative, even if the claimant did have good cause, the available evidence shows the claimant's discharge was directly related to medical issues that impacted his ability to perform work to the employer's expectations. Modify AT, no good cause, no misconduct, no chargeback, MVI.
We should affirm the appeal tribunal decision concerning good cause. Although the claimant timely received the AT1 hearing notice, he failed to attend the hearing because he misread the instructions and failed to pay attention to the time of the hearing. As the claimant was not prevented from participating in the hearing due to circumstances beyond his control, he did not establish good cause. Concerning the job separation, though the claimant received various warnings for his work performance, the record suggests that the claimant continued to perform in a substandard fashion at the workplace. Since the claimant was warned about his work performance and thereafter continued to perform in a deficient fashion, the claimant's conduct was mismanagement of his position of employment and was misconduct connected with the work. Hence, we should affirm the AT decision. The claimant did not establish good cause for missing the AT1 hearing. Misconduct, no chargeback.
Reverse the AT, claimant established good cause for AT1, resubmit.
We will resubmit the case.
Case number 3281278, Commissioner Dimerson.
We should grant a rehearing in this case. The claimant called in almost 2 hours late and missed the first AT hearing. Staff notes taken at the time that she called in for the hearing indicate that the claimant called in late because she believed that the hearing was scheduled at 3 p.m. rather than 8 a.m. This explanation is not consistent with the claimant's testimony provided at the second hearing. While I find the claimant's first explanation to TWC that she missed the hearing because she misread the notice more credible than her later testimony, I'm willing to rehear this case to confront the claimant with her earlier statement made to TWC and to further develop the record on the issue. Accordingly, we should rehear this case.
The decision is not supportable. The claimant established good cause for missing the AT1 hearing because she was unable to appear due to circumstances beyond her control. The claimant called in late due to the side effects of a newly prescribed medication. Regarding the separation, the claimant was discharged without prior warning for allegedly disconnecting a customer call. However, the customer ended the call by hanging up on the claimant. As the claimant has denied the allegation under oath, the employer's secondhand hearsay evidence is insufficient to establish misconduct. Reverse the AT decision. Claimant established good cause for missing the AT1 hearing, no misconduct, and chargeback.
Rehear.
We will rehear the case.
Case number 3295829, Commissioner Dimerson.
We should affirm the appeal tribunal decision. The claimant was terminated for misappropriating cash from the employer. Although the claimant alleged that he took money from the employer's register per the employer's instructions, the available evidence suggests that the claimant disregarded the employer's instructions and availed himself of more cash than instructed for his personal use. Since the record indicates that the claimant disregarded the employer's specific instructions, the claimant's conduct was mismanagement of his position of employment and was misconduct connected with the work. As such, we should affirm the AT decision, misconduct, no chargeback. In the alternative, the commission should conduct a rehearing in this case. The hearing officer failed to develop the record about the total amount of cash available in the employer's register. Since testimony from the employer is critical to ascertain whether the claimant availed himself of more cash than was authorized, we should conduct a rehearing to develop the record and question the parties about the final incident which led to the claimant's separation.
The decision is not supportable. The claimant is the only party to provide testimony. He was discharged after taking $200 from the employer's cash drawer for their approval or with their approval due to a short checks. He has denied taking anything other than what was approved. The text messages submitted show that the claimant was authorized to take the money. Additionally, the messages show that the employer indicated they were discharging the claimant for stating that he might look for another additional work. Informing the employer you are looking for a new job is not misconduct. Reverse the AT, no misconduct, chargeback.
Reverse the AT, no misconduct, chargeback.
Short form dissent.
Yes, sir.
Thank you.
Case number 3301-035, Commissioner Trevino.
The decision is not supportable. The claimant was not an employee of the entity named on the continued claim and was self-employed. There was no separation from work and the continued claim is void. Set aside the AT decision, void the July 6th, 2022 determination, no work separation.
The appeal tribunal decision should be affirmed. The claimant did not quit for a reason that constituted good cause connected with the work. Such, we should affirm the AT decision, voluntary leaving.
Set aside the AT, void the continued claim.
Short form dissent.
Yes, sir.
Thank you.
Case number 3313-793, Commissioner Trevino.
The decision is not supportable. The claimant was working outside with no shade in dangerous 100-degree heat. She asked the employer for a fan or something for shade, but they never addressed her concerns. She had a long-standing medical restriction to avoid direct sun for longer than 1 hour, but she worked for 6 to 8 hours every day in direct sunlight. She had good cause to quit when her concerns were ignored. Reverse the AT, valid claim, no voluntary leaving, void chargeback.
We should affirm the appeal tribunal decision. First, I agree that the claim is valid. Concerning the job separation, the claimant admitted that the employer was working on the claimant's concerns. The employer also testified that it took action to ensure the safety of its employees working outside in the heat. Because the claimant quit without affording the employer a reasonable amount of time to remedy her concerns, the claimant quit without good cause connected with the work. We should affirm the AT decision, valid claim, voluntary leaving, void chargeback.
Modify the AT, valid claim, no voluntary leaving, void chargeback.
Short form dissent.
Yes, sir.
Case number 3320869, Commissioner Dimerson.
The appeal tribunal decision should be reversed. The employer stated that the claimant was not entering information into its system and that many of the notes that the claimant was supposed to leave were blank. In addition, the employer stated that the issue was not that the claimant did not know how to use the system, but rather that he was not utilizing the system as instructed. The latter indicates that the claimant was not following instructions as opposed to working to the best of his ability. As such, the claimant mismanaged his position of employment, which amounts to work-connected misconduct. We should therefore reverse the AT decision, misconduct, no chargeback, adequate employer response.
The decision is correct. The claimant was placed on a PIP because he was not able to meet the employer's expectations. Although the claimant showed some improvement, his PIP was extended. The evidence does not establish the claimant was able to perform to the employer's standard. The employer has failed to provide sufficient evidence to establish misconduct. Affirm the AT, no misconduct, chargeback.
Reverse the AT, misconduct, no chargeback, adequate employer response.
Short form dissent.
Yes, sir.
Case number 3322199, Commissioner Dimerson.
The commission should grant a rehearing in this case. The available record suggests that a first-hand witness for the employer was unable to attend the AT hearing because the witness was out of town at the time of the scheduled hearing. Since testimony from the employer's witness is critical to understanding the nature of the claimant's separation, we should conduct a rehearing to obtain testimony from the employer's first-hand witness about the final incident which led to the claimant's separation.
The AT decision should be affirmed. The employer provided no firsthand testimony to support their allegations that the claimant was discharged because he left work early or without authorization and that he slowed production. The secondhand testimony and the unsworn statements the employer relied on were contradictory. The claimant denied the allegations of misconduct. Therefore, the employer has failed to meet its burden proving that the claimant engaged in actions that could be considered misconduct connected with the work. Affirm the AT, no misconduct, chargeback.
Rehear.
We will rehear the case.
Case number 3329121, Commissioner Trevino.
The decision is not correct. The claimant provided to the employer notice of his intention to resign and accept work with another employer. The employer contacted his future employer and informed them that the employer wished to keep the claimant. As a result, the new employer rescinded the offer. After the offer was rescinded, they decided to accept the claimant's resignation because they did not believe he liked management. The employer effectively discharged the claimant by contacting the new employer and having the offer rescinded, then accepting the resignation. Reverse the AT, no misconduct, chargeback.
We should affirm the appeal tribunal decision. The claimant quit for another job that did not materialize. Because quitting for another job is a personal reason for quitting, we should affirm the AT decision. Voluntary leaving, no chargeback.
Affirm the AT, voluntary leaving, no chargeback.
Short form dissent.
Yes, sir.
Case number 3337052, Commissioner Dimerson.
The appeal tribunal decision should be affirmed. The claimant was discharged for excessive gaps in her daily call route. The claimant had been warned previously about the same issue. Moreover, the employer indicated in its file documentation that the claimant admitted to taking personal calls several times a day. As such, the claimant's actions constituted mismanagement of her position of employment, and we should affirm the AT decision. Misconduct, no chargeback.
The AT decision is not supportable. The employer has failed to present evidence on a specific act or omission on the claimant's part that led to her separation. Instead, they made references to excessive gaps on her phone records. The claimant has credibly explained that any such gaps were due to her completing other necessary work that would not be reported on the phone records. The claimant has denied the allegations regarding making personal calls throughout the day or falsifying any records. As such, the employer's secondhand evidence of the allegations are insufficient to overcome the claimant's sworn denial. Reverse the AT, no misconduct, chargeback.
Reverse the AT, no misconduct, chargeback.
Short form dissent.
Yes, sir.
Thank you.
Case number 3356851, Commissioner Dimerson.
We should affirm the appeal tribunal decision. The claimant was discharged for unprofessional, inappropriate, and harassing behavior towards coworkers. She had received prior warnings for similar behavior. Claimant's behavior during the final incident was reported to the employer by a disinterested witness, the security guard working at the client hospital where the claimant and her coworkers were performing services. This hospital staff member witnessed the claimant harassing behavior and felt compelled to report it to the hospital, who in turn reported it to the employer. This evidence is more credible than the claimant's self-serving denial. Thus, because the claimant continued to harass coworkers after previous warnings, she mismanaged her position of employment. We should affirm the AT decision. Misconduct, no chargeback.
Okay, the decision is not supportable. The claimant has repeatedly denied the allegations of misconduct, while the employer relied on hearsay testimony and unsworn statements. The employer has failed to meet its burden of proving that the claimant engaged in actions that could be considered misconduct connected with the work. Reverse the AT, no misconduct, and chargeback.
Reverse the AT, no misconduct, chargeback.
Short form dissent.
Yes, sir. And that was the last UI case pulled for additional discussion on docket 6. You should have received the UI short form dissent list for docket 6.
I'll move we accept staff recommendations on the remaining UI cases on docket 6, except for the cases on which I'm dissenting as reflected on the UI short form dissent list for docket 6.
Yeah, I concur. Second, the chairman's motion, except for the cases on which I'm dissenting as reflected in the UI short form dissent list for docket 6.
And I concur with Chairman's motion, except for those cases on which I am dissenting as reflected on UI short form dissenting list for docket 6.
And the motion passes with the exceptions noted.
Thank you. Proceeding to docket 7.
Case number 2943590, Commissioner Trevino.
I agree that the employer failed to establish good cause for their failure to appear at the AT1 and AT2 hearings. Regarding the job separation, the AT decision were left the initial determination in full force and effect are not supportable. The claimant was absent from work due to medically verifiable illness of her minor child and was not allowed to return to work without a doctor's note, which she could not obtain due to the pandemic. Therefore, the claimant was discharged for reasons other than misconduct connected with the work. Modify the AT. Employer failed to establish good cause for AT1 and AT2. No misconduct, no chargeback, MVI.
We should modify the appeal tribunal decision. First, I do not dispute the good cause finding. Concerning the job separation, although the claimant alleged illness of her child as a basis for quitting, the record shows that the claimant failed to inform the employer about her child's illness or provide the employer with a doctor's note prior to her resignation. The claimant thereafter turned in her resignation notice and was a no-call, no-show with the employer. Since the preponderance of the evidence suggests that the claimant quit due to personal reasons unrelated to work, we should modify the AT decision. The employer did not establish a good cause for missing the AT hearing, voluntary leaving, no chargeback, adequate employer response.
Modify the AT. Employer did not establish good cause for AT2 or AT1. No misconduct, no chargeback, MVI.
No good cause in either case. No misconduct, no chargeback, MVI is the majority vote.
I'm going to agree with that.
Thank
The
you.
rule-
Unanimous
Yeah,
decision. No misconduct, no chargeback, MVI.
MVI.
Case number 2973134, Commissioner Trevino.
The AT2 decision is not supportable. At the time of the initial hearing, the claimant was unaware that he needed to register for the hearing because he was at work and left his hearing packet at home. The commission engages individuals to return to work, and the claimant should not be penalized for missing the hearing because he was at work. Reverse the AT2 decision, good cause for missing the AT1 hearing, and resubmit for a summary of the merits.
We should affirm the appeal tribunal decision concerning good cause. Although the claimant timely received the AT1 hearing notice, he failed to attend the hearing because he misread the hearing instructions and was unaware that he had to register prior to the start of the hearing. Since the claimant was not prevented from attending the AT hearing due to circumstances beyond his control, the claimant did not establish good cause. Concerning the earning adjustment issue, the record shows that the claimant failed to report all of his earnings, which resulted in an overpayment. As such, we should affirm the AT decision. The claimant did not establish good cause for missing the AT1 hearing, earning adjustment of $299.
Reverse the AT. Claimant established good cause for AT1, resubmit.
We will resubmit the case.
Case number 3265745, Commissioner Trevino.
The AT decision is supportable. The claimant informed the employer that her relief had called out She was told to stay until the store manager arrived, but she informed the employer she had to leave to pick up her child. The claimant stayed 40 minutes past the end of her shift before closing the store and leaving. Though the employer alleged that the claimant left early, the employer failed to submit camera footage to support their allegation. Since the claimant stayed past the end of her shift as long as she could before she had to leave to pick up her child, the claimant's actions did not constitute misconduct. Affirm the AT, no misconduct, chargeback. In the alternative, this case should be submitted for a rehearing in order to obtain the camera footage that showed what time the claimant left the store.
We should reverse the appeal tribunal decision. The employer testified that the claimant acknowledged the employer's policy, which required its employees to stay up to 45 minutes after their shift if requested. The claimant was terminated when she failed to adhere to the employer's reasonable request to wait for a manager to cover the employer's store. Since the record shows that the claimant declined to adhere to the employer's reasonable request and thereafter left the employer's premises prior to the completion of her shift, the claimant's conduct was mismanagement of her position of employment. Hence, we should reverse the AT decision, misconduct, no chargeback, adequate employer response.
Affirm the AT, no misconduct, chargeback.
Short form dissent.
Yes, sir.
Case number 3278774, Commissioner Trevino.
The AT decision is not supportable. The claimant's son was born premature and was on life support. The claimant quit to be at the hospital during that time. The claimant was not sure whether his son would survive and wanted to spend his time at the hospital. The claimant therefore had good cause for quitting due to a medically verifiable illness of his minor child. Reverse the AT decision, no voluntary leaving, MVI, no overpayment.
The appeal tribunal decision should be affirmed. I empathize with the claimant's personal circumstances. However, the claimant provided a fact-finding statement, which was closer to the time of the separation, that he quit because of the pay and was not receiving enough hours. In the same fact-finding statement, the claimant disclosed that the hours and pay had never changed since he started working with the employer. Moreover, the claimant did not address his issues with his pay or hours with the employer. Accordingly, the claimant quit without work-connected good cause, and we should affirm the AT decision, voluntary leaving, overpayment.
Affirm the AT, voluntary leaving, overpayment.
Short form dissent, ma'am.
Yes, sir.
Case number 3290481, Commissioner Dimerson.
The appeal tribunal decision should be modified. The claimant testified that he was discharged for taking a long bathroom break. In the claimant's online appeal, he states that he had never been written up for using the restroom. While there were maybe several explanations with varying detail as to why the claimant was in the restroom, his online appeal indicates that after lunch, he'd eaten something that made his stomach sick. Accordingly, it is not unreasonable to conclude that the reason the claimant was in the restroom for an extended period of time was due to illness. As such, the claimant should be qualified for benefits, but the employer's account should be protected due to the separation being the result of the claimant's illness. We should therefore modify the AT decision, no misconduct, no chargeback, MVI.
The AT decision should be reversed. The employer discharged the claimant for an alleged extended bathroom break. However, the employer did not appear to any offer of testimony on the matter and did not show that the claimant took an extended bathroom break or had ever been warned for such matters. The employer did not meet its burden establishing the claimant committed any misconduct connected with the work. Reverse the AT, no misconduct, chargeback.
Affirm the AT, misconduct, no chargeback.
I'm going to agree with the chairman.
Majority vote is misconduct, no chargeback. Did you want a dissent, sir?
No, I'll go ahead and agree with the MVI.
The majority vote is misconduct, no chargeback. So,
Okay, then I'll go ahead and short form dissent.
thank you.
Thank you, ma'am.
Case number 3332664, Commissioner Trevino.
The AT decision is not supportable. The claimant had a serious medical condition, multiple sclerosis, and had been advised by her doctor to quit in order to avoid exposure to COVID. Though the claimant had been granted intermediate FMLA to cover her absences due to her medical condition, the intermediate FMLA did not mitigate the claimant's exposure to COVID or the resulting risk to the claimant due to her serious health condition. Since the claimant quit due to medically verifiable illness, the claimant had good cause connected with the work for quitting. Reverse the AT, no voluntary leaving, bill reimbursing employer. And the alternative, this case should be submitted for a rehearing in order to admit the claimant's medical documentation and evidence, and to question the claimant regarding when she was first given instruction to quit due to her medical condition.
When the appeal tribunal decision should be affirmed, the claimant's testimony reflects that she quit due to medical reasons. The claimant stated that she was told by her doctor to quit. However, the claimant does not appear to have immediately heeded that advice, and she continued to work for the employer for multiple months thereafter. In addition, the employer stated that the claimant gave another personal reason for quitting aside from her medical issue. Moreover, the employer stated that the claimant could have continued working for the employer had she not resigned. Accordingly, the claimant quit without work-connected good cause, and we should therefore affirm the AT decision, voluntary leaving, reimbursing employer not billed.
Affirm the AT, voluntary leaving, reimbursing employer not billed.
Short form dissent.
Yes, sir.
Case number 3334153, Commissioner Trevino.
The AT decision should be modified. The claimant is a veteran and quit due to his medical condition that made it impossible for him to walk as much as the job required. He should be qualified for benefits and the employer's account protected from chargeback. Modify the AT decision, no voluntary leaving, no chargeback, MVI.
The appeal tribunal decision should be affirmed. The claimant quit his job due to medical issues. However, the claimant did not provide any documentation from a physician advising him to quit his job. As such, the claimant quit his job without work-connected good cause, and we should therefore affirm the AT decision of voluntary leaving, no chargeback.
Affirm the AT, voluntary leaving, no chargeback.
Short form dissent, ma'am.
Yes, sir.
Case number 3335399, Commissioner Trevino.
The decision is not supportable. The claimant was hospitalized for several days and missed work. After returning to work, the employer informed her she could not miss any more days. The claimant encountered technical issues and was unable to log into the employer's system. She reported the issue to her supervisor. The employer decided to discharge the claimant. The claimant's inability to work was due to technical issues with her employer's system and not misconduct connected with work. Reverse the AT, no misconduct, chargeback. In the alternative, as most of the claimant's absences were due to hospitalization, I could agree to no misconduct, no chargeback, MBI.
The appeal tribunal decision should be affirmed. The claimant was discharged based on violating the employer's attendance policy. The claimant was aware that if she incurred another unexcused absence, she would be terminated. Nonetheless, the claimant incurred another unexcused absence. The claimant was also aware that the reason for a final absence constituted an unexcused absence. Accordingly, the claimant's actions constituted work-connected misconduct, and we should therefore affirm the AT decision, misconduct, no chargeback.
Affirm the AT, misconduct, no chargeback.
Short form dissent, ma'am.
Yes, sir.
Case number 3336262, Commissioner Dimerson.
We should modify the appeal tribunal decision. The claimant announced at a meeting that she would no longer be working for the employer. She followed that statement by emailing the employer her written resignation and thereafter stopped reporting to work. When the AT asked why she chose to quit, the claimant was unable to clearly articulate any reason that would constitute good cause connected with the work for quitting. Although the claimant later experienced serious health issues, those occurred after she had resigned and were not the reason for the job separation. Thus, because the claimant initiated the job separation and did not establish good cause connected with the work for quitting, disqualification is appropriate. We should modify the AT decision, voluntary leaving, taxed governmental employer, an overpayment of $1,449.
The AT decision is not supportable. The claimant stopped working due to her personal illness. As such, the claimant left work due to a medically verifiable illness. Reverse the AT decision, no voluntary leaving, tax governmental employer, no overpayment.
Affirm the AT voluntary leaving tax governmental employer overpayment.
Yeah, short form dissent, ma'am.
Yes, sir. Yes, sir.
Case number 333-6305, Commissioner Trevino.
The AT decision is not supportable. The claimant was discharged for failing to follow the employer's instructions to remain at the cold storage facility until his lead arrived. But the employer presented no testimony from the peers who allegedly communicated the instruction to the claimant or the lead who issued the instructions to the peers. The claimant established that he was never told that he was supposed to remain at the cold storage facility. The claimant cannot be held responsible for failing to follow instructions that were not communicated to him. Reverse the AT, no misconduct, chargeback.
We should affirm the appeal tribunal decision. The claimant acknowledged that his lead driver had not been giving him instructions directly, but instead had been relaying instructions to him through other delivery drivers. This neither invalidated nor allowed the claimant to ignore his lead's instructions. Because the claimant failed to follow instructions after prior warning, he mismanaged his position of employment. We should affirm the AT decision, misconduct, no chargeback.
Reverse the AT, no misconduct, chargeback.
Short form dissent.
Yes, sir.
Case number 334-3483, Commissioner Trevino.
The AT decision is not supportable. The employer has characterized this assignment as a temporary assignment, but the claimant's only assignment while working for the employer was working as an assembler for a year and a half. Section 201.011, 20 and 21 of the Act describe a temporary employee of a temporary help firm as an employee who has worked for the client to support or supplement the client's workforce during employee absences, temporary skill shortages, seasonal workloads, or special assignments and projects. The claimant's year and a half long job clearly meets none of these conditions. Since the claimant was not a temporary worker, the reporting requirement in section 207.045H of the Act do not apply. The claimant was laid off when the job ended under non-disqualifying circumstances. Reverse the AT, no misconduct, chargeback.
We should affirm the appeal tribunal decision. After the claimant's assignment ended, she failed to report for a reassignment as required by policy because she simply forgot. Thus, under section 207.045H of the Act, the claimant is considered to have quit without good cause connected with the work. Should affirm the AT decision, voluntary leaving, no chargeback.
Reverse the AT, no misconduct, chargeback.
Short form dissent.
Yes, sir.
Case number 3344227, Commissioner Trevino.
The claimant filed an appeal after the deadline stating it was his second attempt. Since the claimant has alleged filing an earlier appeal, this case should be set for a timeliness rehearing to address whether the claimant filed a timely appeal. Rehear.
The claimant's appeal to the commission was 6 days late, and we have no jurisdiction to consider the underlying merits. Thus, we should dismiss the claimant's commission appeal as late and leave the underlying AT decision in full force and effect.
Rehear.
We will rehear the case. And that was the last case pulled for additional discussion on docket 7. You should have received the UI short form dissent list for docket 7.
I move we accept staff recommendations on remaining UI cases on docket 7, except for the case on which I'm dissenting. as reflected on the UI short form dissent list for docket 7.
And I second the chairman's motion, except for the cases on which I'm dissenting as reflected in the UI short form dissent list for docket 7.
And I concur with the chairman's motion, except for those cases on which I am dissenting as reflected on UI short form dissent list for docket 7.
Motion's passes with the exceptions noted.
Thank you.
Thank you. Is there any other order of business to come before the commission?
None here.
No, sir. Is there a motion to adjourn?
So moved.
I second the motion to adjourn.
Been moved and seconded to adjourn, and we are unanimous on that motion. We're adjourned.